Good morning, everybody. We'd like to get started. If you could, find your seats. Probably get the doors closed for us. And please continue eating, enjoying your breakfast. We'll get started with the actual program about 9 o'clock. My name's Stephen Brueggemann. I'm an attorney at Evans & Dixon. I've been there for about 15 years. I'd like to welcome everybody here to our production of You Don't Know Jack. We took a year off from our seminar last year. We're looking to try something different, a little different, and we also moved it to a morning session. We ultimately came up with a play of sorts. As you watch, please consider any questions you might have or even alternate fact patterns based upon the scenario being played out. We did our best to come up with something interesting. Clearly, we are making a couple leaps throughout this. No case gets resolved over the course of 2 hours. We should have some time at the intermission for questions. At this time, I would appreciate if everybody take a moment just to check your phones. Also, for people going home or returning to work afterwards, there will be some boxed lunches afterwards. Please take them with you. And also, please do not forget to sign in for your respective credit hours. You can do that afterwards. The sign-up sheets will be out there. Also, we appreciate your feedback. So afterwards, we may have SurveyMonkey go out. Let us know. Let us know if you like the morning. Let us know if you like how it was presented. Let us know ideas for next year. This is sort of a first-time go at this, so bear with us. I'd also like to recognize, since the last time we had a seminar, we've actually added quite a few attorneys to Evans & Dixon. Some of them are with us today, some aren't, but I'd at least like to go through the list. Alex Labarge. You can stand up. Andrew Wiles. No, Andrew? Christina Peters. She works in our St. Louis office. Jessica Dodd. John Ryan. Kelly Anderson. I'll get one here soon. Lori Leschner. Yay, all right. Molly Anderson. And I didn't see Rachel. Is Rachel Jag here? No. Well, she just passed her bar, so let's give her a round of applause. Ryan Cox. Ryan Reed. There's a Ryan. All right. And Todd Hilliker also joined us. Some of you may have had cases with Todd in the past, but he recently joined our firm. So, with that, I will set up the scenario for you. Oh, and also, if you have questions throughout, text them to that number. I have a very good screener, and she can send them on. Our claimant is a male pizza delivery driver for the pizza joint. He has an average weekly wage, as reported by the employer, $300 a week. He makes $10 an hour, so we're thinking he works about 30 hours a week. He's 19 years old. He was born, interestingly enough, on April 20, 1997. What? During a delivery on November 22, 2017, Jack was involved in a motor vehicle accident while making a delivery. He drives a newer model vehicle, which he owns outright. The accident occurred as claimant was trying to beat a yellow light at an intersection. He was T-boned by a truck on the passenger side. His car was towed from the scene. He was found unconscious in the driver's seat. No seatbelt, airbags deployed. He was extricated from the vehicle and taken to a local emergency room. He was in and out of consciousness during the ambulance ride to the hospital. Of course, Jack has retained counsel. Oh, sure, I can introduce the players. We've got work comp defense attorney Elizabeth Schock Legal. We got an adjuster, no nonsense Nancy. Our counsel representing Jack Black on both sides is Money Miles. On the civil case, we got Stingy Sean, and we also have Careful Carrie as the adjuster. Money, I'll leave it to you.
Money Miles, it's got to be you.
Hey, Nancy, how are you?
Fine, how are you?
I'm good, thanks.
I haven't heard from you lately.
Well, you know, I got to lay around thinking about my money, so.
I saw your new billboard on 55.
Did you like that?
Oh.
Get that money, honey?
Pretty good. It's a decent
Yeah,
You're
yeah.
going to give Ron Edelman a run for his money, babe.
I know. I'm thinking about changing my slogan, but, you know, we'll talk about that later.
Oh, I can't wait.
Hey.
So what havoc are you wreaking today?
All right, so my new guy is Jack Black. Is that ringing a bell?
Yeah. Another one of my heroes.
Yes, young guy, driving his nice Cadillac. He has some serious injuries. He's still in the hospital.
Yeah. He's got a concussion. He's treating with Dr. Head. We're getting him TTD. And I wanted to know, can I get a recorded statement from him?
Why are you acting brand new, Nancy? You know you can't get a recorded
I'm
statement
trying to
from
save
him.
you the cost of a depot, lady. That's all I'm trying to do.
Look, I tell all my clients, don't let those tapers mess with your papers, okay? See, how it goes is I have to speak in rhyme so they remember these things.
Money, you never change.
Hey.
All right, I'm sending this over to Beth Schock Legal, and she will probably want to get your client's depot.
Well, we'll think about it. I'll let him treat, and in the meantime, you know, I'll get back with you later.
I'm sure I'll be talking to you.
All right, have a good one.
Stay cool.
You know it.
We need another ring. There's no ring. Oh, okay. Ring, ring, ring.
Elizabeth Schock Legal.
Hello, Ms. Schock Legal. How are you? This is Nancy. No nonsense, Nancy.
No nonsense. What's up? What do you got for me?
I got a pothead for you.
Oh, another one.
Yes.
Is this one of your friends?
That's not funny. He's represented by Money Miles.
Oh, good old
So
money.
you're in for a long run here,
Show
girlfriend.
me the money, honey.
Yep, you got it. She won't let me get a recorded statement, so
Of course not.
I want you to take his depot.
So what do we have?
He was injured. He was injured in the course and scope, delivering a pizza, T-boned. I don't have the police report yet, so I'm not sure about liability. He's 19, paying him TTD, earned $10 an hour, working 30 hours a week, so I'm paying him $200 a week. There's something really sketchy about this guy, though. According to the employer, I didn't tell you this part. He lives in an apartment above the pizza joint, and they give it to him for free. The pizza,
Oh.
that's part of his deal.
Nice.
And he also gets free meals. How much pizza can one eat is beyond me, but he gets free meals.
Well, if you're a pothead, I
A
understand
lot
it's
of
quite
pizza.
a bit.
Yeah, lots of pizza.
But you would know more about that than me.
Pizza and Cheetos.
Okay, so no question about accident, right?
Nope.
And we're sure that he was in the course and the scope. He's a delivery guy. Are we sure that he was on a delivery?
Yes.
All right. And you said he's treating. Where's his treatment stand?
He's treating with Dr. Head for his concussion. And
Okay.
He's still under active treatment.
Okay. And you said that you're paying him TTD.
Correct.
Now, you're paying him based on his $10 an hour at 30 hours a week?
Correct.
All right, so you're paying him $200 a week?
Correct.
All right, now let's talk about that apartment and the meals that you mentioned.
I got a quick question if you want to jump through that fourth wall real quick.
Oh, geez, I was so in character. What?
What state are we in?
We're in
Well,
Missouri.
we're in Missouri.
Okay.
Yes.
just
Where do
so
you
everybody
think we
knows.
are? Where are we sitting?
Yes. Stupid question. All right, back in character.
I'm going to have to check that the text screener again.
Oh, so is someone out here's question? Stupid question.
No, it was a great question.
If you don't know that you're in Missouri, we've got problems bigger than this pothead. Okay. All right. So Nancy, let's talk about the rate that you're using.
Okay.
And I'm going to be out of character again as I go through the concerns about calculating the average weekly wage under the statute when you're dealing with someone who receives gratuities, who receives room, board, those kind of benefits as part of their pay. And then we're also going to talk about the fact that Jack Black is under 21 years old. So under 250, Section 2, when we're calculating the average weekly wage, and I think some people forget about this, and at times our opposing counsels will bring it up, and at other times they don't, but gross wages under the statute does include board, rent, as well as gratuities. So in Mr. Black's case, do we include the $400 that he's getting per benefit for the apartment? And do we include the meals that he's getting per day, which is estimated at about $10? And then also, he's a pizza delivery guy, so we're sure he's getting gratuities and tips, and do we include that in his calculation of his average weekly wage? Well, the question is, are those benefits going to continue during his disability? So in other words, is the employer still going to allow him to live in that apartment rent-free? If the answer is yes, then we don't include it, because why would we pay him for something that he's already getting? If they're going to now make him pay $400 a month, then we have to include that value as to what he had before. Same with the board, the meals. If they're going to continue to allow him to eat pizza when he wants, we don't have to include it. And then with gratuities, you know, the way we treat gratuities, and the statute specifically says that we only include them if they report it on their income taxes, which makes sense, right? So I always tell the opposing counsel when they bring up the gratuities portion is show me the income tax returns where they claimed their gratuities and that they pay taxes on it. The other part of this scenario is that Mr. Black is under 21 years old. So under 250 Section 6, we have to determine whether he has any increased earning capacity because he's a minor. And for the purposes of this statute, a minor is considered anyone under the age of 21. And then you look at the increased earning capacity for the next 3 years. So if Mr. Black has some sort of evidence to show that in the next 3 years he's going to make more money, perhaps he's in school, those kind of things, then we have to increase his rate. That only applies to permanent partial disability, not the temporary benefits. All right, back in character. Nancy,
Yes.
no nonsense.
Yes.
So a couple questions I have for you regarding the rate. Will Mr. Black's rent-free living continue, or are they going to start making him pay rent?
No, it'll continue.
Okay. And are they going to continue to allow him to eat pizza when he wants?
That's what the employer said.
Okay. And do we have any proof or evidence that he claims his gratuities on his income taxes at this time?
I have no evidence of that, and I don't know if he claims them. I guess you can ask Money about that.
I will, and I will also ask him at his deposition. With regard to him being a minor, you know, because you're the best in the biz, that we have to consider as increased earning capacity.
Correct.
Do we have any evidence to suggest that Mr. Black's going to be doing something more than delivering pizzas in the next 3 years?
No, Papa John said he is not. There's no indication that that he's going to leave, that he's just going to be there forever.
Okay, so he's not in school?
No.
Okay. Do we know whether he has a high school education?
I don't know the answer to that question.
Okay, all right, well, we can ask him.
All I know is he's driving a new black Escalade. So what does that tell you?
I don't
tell
know.
you, it's sketchy.
What do you think?
I think he's selling drugs, but, you know.
So you think he's selling the drugs, not only doing the drugs?
What 19-year-old works at a pizza joint and has a Cadillac?
I don't know. I don't know the answer to that.
Well, you find out.
None of the delivery guys that come to my house with pizza, that's for sure. Okay, well then at this point, let's stick with what your calculation is. Let's use the average weekly wage at $300. If Money Miles can show me that he includes his gratuities on his income tax returns, we'll have to adjust. If Money Miles can prove that he has increased earning capacity, or when I take his deposition, he testifies that he is indeed trying to further his employment opportunities, then we might have to increase with regard to the permanent partial disability. And then obviously if the employer decides to stop letting him live there or stop giving him meals, let me know that as well, okay?
Right, and I guess if you could ask Money, once we get the police report, well, just, I guess, go ahead and, if she's going to pursue a third-party case, ask her to protect our interests.
Absolutely. So the takeaway on this, Nancy, on this wage thing is, you know, it's important to not only consider wages, but if an individual is getting some other benefit that has a value to it as well.
Right.
Well, since I have you on the phone and you're on the clock, I'm charging you by the minute.
Yeah, but I've got this timer going right here, girlfriend.
How's life? How's your family?
You don't care about my family, and I don't care about my family.
Very good. Well, I will get a hold of Money, get the deposition scheduled as soon as I can, and I'll also ask her to put in writing that she will protect our subrogation interest in any third-party recovery if, in fact, the other driver was at fault, and then I will get back to you.
Sounds perfect.
Oh, one more thing, Nancy.
What?
You talk about him being a pothead. Is that a term from, like, the 70s or
Are you making fun of my age?
Never. Did we drug test him? Do you know?
Yes, we did. He was drug tested at the hospital, and it did come back positive.
No, we don't know the results yet.
No,
Nancy.
we do not know the results yet.
Yeah, okay.
The results are not known. I just kind of went ahead a little bit. Okay, he was drug tested.
You think it's going to be positive?
I'm positive it's going to be positive.
Okay. Unfortunately, under the statute, that's not enough. But hey, when you get those actual results, let me know, okay?
Okay.
All right, so I'm going to get his deposition, and then I will, I'll let you know what Money has to say. And as always, I look forward to working with you.
Oh,
No
me too.
nonsense.
Me too. Let's do lunch.
Questions?
Yeah, you mentioned if he can show, if the claimant can show an increased earning capacity, meaning is he in college? Is that what it means? Is he in college? Does he have to take one class, two classes? Does he have to be full-time?
I mean, not necessarily, but I think that judges and the commission are pretty liberal about interpreting what increased earning capacity is with regard to minors, and probably rightfully so, especially if you have a 16, 17-year-old that is working for minimum wage. You know, high school might be enough to convince someone that they have increased earning capacity. Grades would come into play. You know, in Mr. Black's case, if he's 19 and he's been there since he's 16, and like Nancy said, he has no intention of going anywhere anytime soon, that would all be relevant. If he's in community college, I think that's pretty strong evidence that he's at least attempting to further his earning capacity. However, you know, you get the transcripts. If he's not attending class, if he's got Fs, then maybe that's evidence of the contrary.
Very good.
And remember, it's just for permanent partial disability. We don't adjust it for his temporary benefits.
Ring, ring.
Hi, this is Careful Carrie.
Hey, Careful Carrie, this is Money Miles. Money Miles. What, like, do you like that? Like, you know, like Warenberg Theater says, hey, Warenberg, I want to do like the Money Miles thing. Do you think that works?
I'd try something different.
All right, fine. Okay, so seriously though, I'm calling regarding my client, Jack Black. He was seriously injured in a car accident back in November, and that accident was caused by your non-driving client, Cautious Ken.
Well, Money Miles, questionable liability and an accident right under your billboard. I had a feeling you'd be calling. We're still looking into liability. Does your client intend on making a claim?
Did I call you? Of course he's making a claim. He's still treating right now, but again, you know, this is a simple case. Police report points to your client's fault. I think we can wrap this one up pretty soon after he's done treating. Can you tell me what your client's policy limits are?
Well, unlike most of your clients, Cautious Ken carries 100-300.
Hey! All right.
Is your client the only one injured?
Yes, he was driving at work for the pizza joint. He was the only one in the car.
Okay. Have you obtained all his bills and records? If so, I'll take a look at them.
Not yet, but I will send you a package. And just to give you a heads up, you know we'll be demanding the full 100,000 policy limits.
I wouldn't expect anything less.
That's right. I'll send you a letter of representation and my formal demand.
I'll look forward to it.
All right.
Ring, ring.
This is Stingy Sean.
Hey, Stingy, I think I have a new file for you. I just received a call from none other than Money Miles from a lawsuit stemming from a car accident. Apparently, some kid got hurt driving a pizza delivery car, and we have limits at 100.
Well, that's fine. Just send it over. Do you know much about it? And going forward, I am significantly more boring than Money Miles. So just so we all get that straight. That's just in my general nature as a defense attorney.
At this point, we don't know much. I know it's a young kid. There's about $15,000 in medical, but it looks like most of it is diagnostic from the ER.
Well, after your initial review, do you have any idea what you want to do or what?
Well, my initial thought is it's Money Miles. We know she's not going to trial, so I'd say sit on it, which I know you'd be okay with. Just kidding. But I don't think it's worth that much. But once you get time, look at the demand and let me know what you think.
I will.
3 weeks later.
Dun, 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 dun.
Ring, ring.
Stingy Sean.
Stingy Sean, Money Miles.
Hello, Money.
Hey, if it don't make dollars, then it don't make sense. How are you?
I am so much better now that you called me this afternoon.
Great, great. I was giving you a follow-up call on Jack Black. Did you get my demand packet and a copy of the suit?
Yeah, I did. It was ridiculous as always.
It's never ridiculous. Never. I told you I take serious cases for serious money. Did you look at it?
I did. I just don't see it. I saw you had a $15,000 paid medical and you're asking for 100. You know, there's some questionable liability here. I mean, this isn't a policy limits case.
It's always a policy limits case. I want my money, 100,000.
I haven't had time to look at everything. I want to look at some past prior medical, if it's available, and whether treatment was actually necessary with this kid, and whether he had any pre-existing conditions. I just don't know those things yet, so I can't do it now.
Are you reading from a script right now?
I am.
Like,
This is my, yes. The answer is absolutely.
like, that's what defense counsel always says. It's like Stepford
This
adjusters
is actually in
and
my office right now.
Westworld shenanigans. Look, at the end of the day, I sent you a demand packet. It's proper. I complied with the new 537 statute. I need you to just write me a check.
Sure.
Thanks.
Yeah.
We're done.
Okay. Sally, we have to
Hey,
break.
Sean, do you want me to run out and get your checkbook for you?
There you go.
You better go check that account first. So to break through real fast and talk about the new 537, I will be brief. As Money has discussed, she has complied with the new 537.058 statute. So a bunch of changes happened in Missouri for insurance companies with the latest round of, I guess the governor signed it into bill, or into law, I guess, in last summer. It went into effect August 28th of 2017. And it's a pretty big deal going forward. We don't know what effect it will have because there's just not a lot of law. I mean, because what we need is, what you see is you have these new statutes, right? And they have the way they're intended to work, and then you have tons of unintended consequences. And so here we don't know what those consequences are, but right now what we do have is a new statute. So if you guys are familiar with, there was a 537065, which was a statute in Missouri that allowed essentially plaintiffs to enter into agreements with claimants, defendants, so what would happen was plaintiffs would agree to not execute on a defendant's assets and go after only the insurance company. This happened in bad faith claims. In Missouri, bad faith claims can result in judgments in the millions and millions of dollars. And it was becoming pretty easy to set up insurance companies for bad faith. So in the past, if you were an insurance company and you had a claim and you were going to seek a declaration of coverage or you were going to defend under a reservation of rights, that was a massive risk for setting yourself up for bad faith. And then if the plaintiff and the defendant entered into an 065, what would happen would be is your plaintiff and your defendant would have a sham trial where the defendant would lay down. There'd be a judgment against him for $10 million for a pretty small claim. And the insurance company had no right to get into that lawsuit and defend on the facts. And the plaintiff would then take that judgment and execute against your insurance company. And the insurance company, the only defense they would have would be their coverage defenses. Now, with the new 065, it can only be entered into if the insurance company has an opportunity to defend and declines to do so. And I guess the biggest effect is that now, if a plaintiff and a defendant enter into that 065 agreement, the plaintiff and the defendant have to give the insurance company 30 days notice, which allows the insurance company, they now have a right to intervene in that sham trial, essentially, and defend on those damages, so they're not stuck holding the bag on a $15 million judgment on a claim that had $100,000 in medical, right? So that's a big deal. The other issue you see is when you would see these in instances when plaintiffs' attorneys would send these unreasonable time limit demands, 10 days or 15 days, with not giving the insurance company much information on the claim, saying, give me your policy limits or I'm gonna go through with this 065 agreement. And you're basically setting up the insurance company for bad faith. So the new statute, 537058, tries to do away with that and give the insurance company a fighting chance in thwarting off these reasonable opportunities to settle. So now, if a plaintiff intends to try and set up a insurance company for bad faith, what they have to do is, in order to give the insurance company a chance to settle the claim reasonably, they have to comply with the new statute, right? So the new statute is kind of listed up there. The first thing they have to do is, let me see here, is they have to list all of the claimant's healthcare providers, which is huge, right? Because that's your claim. Your claim is how much medical there is, what the medical is, and the extent of it. And then if they're making a wage claim, they also have to give you authorizations for, they have to give you authorizations for the medical and for their employer for I think the past couple years if they intend on making a lost wage claim. And then when they do that, they also have to keep the demand open for 90 days. So that gives you guys 90 days to take the authorizations for the employer and for the healthcare providers and get your own medical, and so you can actually evaluate the claim. The demand has to state whether it's open for 90, or whether it's for a sum certain or for like the limits of the policy. It has to contain the date of loss and the claim number, a description of the injury sustained by the plaintiff, the names of the parties that will be released upon the settlement, and it'll give an unconditional release to the insureds for present and all future liability. So I don't know what it's going to do, right? But at this point, it does give insurance companies a chance to reasonably evaluate claims before they get teed up for one of these, the bad word is bad faith. And it's like a nightmare for everybody. So that's what it is. And that's what Money Miles is trying to do. But
That's right. That's right.
Sean, do we know how, at least your immediate adjusters, how it affects their day-to-day operations?
I'm glad you asked, Steve. Thank you. No, we don't. Actually, we don't. We have no idea. Because as I said,
Another stupid question.
Yeah, that is a stupid question because I think I asked it originally. We don't know. From an adjuster standpoint, we don't know what effect it will have because it's so new. And there hasn't been enough there's definitely no cases at the appellate level that have ruled on this yet. And honestly, I haven't seen any at the trial court level, so we don't really know what effect it'll have. You assume that the courts in Missouri will shoot holes through it. That's what they do. So we don't know yet. But what it does do, I mean, for the adjuster receiving the formal demand, it does give you time. But it's essential to know what the requirements are, whether they've been met, and to note your time limit of the 90 days. But those are important, but it does, like I said, it's not gonna, it's not the cure-all for bad faith in Missouri, but it does give us a chance, so.
I have a question, Sean.
Oh,
So, it's a new statute, so obviously we don't have a lot of guidance on it. But have you seen any demands that so far comply with these requirements out of plaintiffs' attorneys?
I have. So I've gotten 3 of them since the statute, and it's actually made my job way easier because I get them while they're in suit, and I don't know at this point why the demands I've gotten at this point, I don't know why they're necessarily complying with them because there's really not a bad faith issue there, but they are nevertheless, and so I've gotten demands that included the letter and then the amounts and the authorizations. It really streamlines what I'm doing because I don't have to, I can get the medical pretty quickly without having to wait for, discovery and motions to compel to get everything, to basically drag stuff out of money because that's what I have to do usually. Mm-hmm.
He's looking at you.
Hey, don't be mad at me. I'm just stacking dollars. All right.
So back to the show.
All right, so Sean, you have my
wait.
stuff. You know the
Question.
clock's
Steve,
ticking.
there's a question.
Oh,
I was actually just going to make a quick comment. I've gotten a few demands, Sean, that the claims council is trying to actually poke holes in. So you're getting some demands where they're saying it's not a policy of advance, they don't have to meet that 90 days. So I'm still getting those 7 and 14-day demands that are completely reasonable and don't have much info. They don't think that they have to comply with the statute unless it's a policy of advance. Additionally, you have situations where they are then sending you a release that they had actually drafted themselves and making that part of the demand, where you have to, if you're going to accept the demand, you have to mirror the demand. Your offer has to mirror it. So that means they're making one of the conditions, you have to execute my release that I drafted. Of course, it doesn't have the language in there that we need or the information that we need for
Why don't you introduce yourself?
Hi, Laurie Leschner, new to the firm. I've been there about a month. I'm a new member in the civil litigation group. But
yikes.
I've had some situations where they're still trying to set you up, they're still trying to poke holes, and you really still need to be on your toes. It's a great effort by the legislature, but I don't know that it's necessarily everything that it's intended to be doing. Obviously, the plaintiff's bar is going to just do everything possible to try to poke holes into it. So still be on your toes. This isn't an automatic.
All right, well, back to the phone. Money, I will look at your demand, and Carrie or I will get back to you with a no, I'm assuming.
I don't like you.
I know.
But again, the legislature
shows.
the legislature was nice enough to give me this checklist to make sure you have everything you need. So clock's ticking.
Well,
Get
thank
my
you.
money.
Okay.
All right, bye.
Any questions? All right.
Ring, ring, ring.
Elizabeth Schock, legal.
Hello, Ms. Shockley, legal. It's No Nonsense Nancy again. How are you?
Hey, no nonsense. Which one are you calling on this time?
Our druggie, Jack Black.
Oh, our druggie.
Objection.
Yes.
Objection. Overruled.
God, could you hear our conversations too? Oh my. Okay.
What's the latest on Mr. Black?
We have a hallelujah. The drug test came back positive.
Ah,
So-
look at you, Nostradamus. You
I
knew this a
know,
long time ago.
I know, I'm so smart.
Yes,
The employer
you
wants
are.
the penalty, the
right.
whole bit,
Okay.
and so
So let's back up. What was it positive for?
marijuana.
All right. And no nonsense, are you aware of the the recent changes to the drug penalty provision in the statute?
That's why I'm here today.
I was just going to say, if not, you need to attend an Evans and Dixon seminar.
Okay.
Okay, so we're going to talk about the post-accident drug testing, the drug penalty, and the changes that recently went into effect. Since Mr. Black's case was from November of 17, this new statute is going to apply. So prior to, I'll touch and just remind everyone what the old law stated. The old law was that if an employee fails to obey a policy or a rule by the employer regarding drug or alcohol use in the workplace, that his or her workers' compensation benefits could be reduced 50% if the injury was sustained in conjunction with the use of alcohol or drugs. In trying these cases, it was very, very difficult to have a penalty stick. And the reasons were, number one, our urinalysis, which is the testing that everyone uses, especially in regard to marijuana, shows metabolites. And the judges and the commission have ruled that metabolites are not the same as controlled drugs. So in other words, because a urinalysis is limited into what it can detect, it shows cocaine metabolites, it shows marijuana metabolites. Those weren't considered in violation of the statute according to the judges and the commission. The other problem we got into was the old statute had the language that the injury had to be sustained in conjunction with the use of the drug or alcohol. So the strict construction of that became, we had to show that the injury or accident happened while the individual was using the drugs or alcohol. So in the case of alcohol, that's pretty simple because we have a standard test, and if they're over the legal limit, and alcohol doesn't stay in your system that long. However, marijuana especially does, and so that in conjunction with literally became, we have to show, and I recently argued this, and my client that I argued it for is in the room, and I was unsuccessful. But basically, we had a drug test come back, and the metabolites were off the charts. I've never seen that high of a level. We had a toxicologist testify that that individual had to have smoked it within a certain time period before the accident. We had the individual testifying that he smoked it on a Thursday, and he fell off a ladder Saturday morning. So we kind of had all our ducks in a row. We gave it a whirl to see if we could get the penalty to stick, and we lost. And basically, I talked to the judge after the case was tried, and I said, do I have to literally show that he has a joint in his mouth when he falls off the ladder? And she said, yeah, that's what you have to show. So we couldn't show that. So we were very limited in taking these drug penalties. What happened with this new statute was an attempt to strengthen our position on the defense side with these positive drug tests. So the changes, we don't have any real feedback yet from the judges or the commission or the Court of Appeals on this interpretation of the new statute. To me, we've added some hoops that we have to jump through that we never had to before. And I think it's really important for everyone to know those hoops. Because now, I guess the positive is, at the bottom, you'll see that if the test is positive for a non-prescribed controlled drug or its metabolites, the employee must prove that the injury did not occur as a result of the drug use. So now they've recognized that limit of the urinalysis, and they've included that metabolites are now considered a non-prescribed controlled drug. So that's a positive, no pun intended. But they've also added these other requirements. So if you have a positive drug screen and you want to take the penalty of 50%, you have to be able to show that that drug test was done within 24 hours of the accident. All right? That's fair to me. I mean, in the past, they didn't have a definitive time, so we were always kind of figuring out what was the time. Was Thursday to Saturday morning enough time? Or was it, does it have to be within 2 days, 1 day, whatever. So now we know that drug test has to occur within 24 hours of the accident. Obviously, that's a problem when you have employees that don't report their accident timely. But for traumatic injuries, you're probably going to be able to comply with this. The most important thing is now the insurer or the self-insured trust must provide the employee with the drug test within 14 days of actual notice of it. So if you are an insurer, if you are an adjuster, if you are a case manager, and you get that positive drug test on your desk, you have 14 calendar days to get that to the employee. And 14 calendar days goes by pretty quickly. So it's really important to know that if you've got a positive drug screen, send it certified mail to the employee. Keep a copy. Make sure that you can show that you provided that to the employee. The employee now must be given an opportunity to do a second test on the original sample. There's no indication who's paying for that, but you have to at least offer that to the employee and make sure you document that you offered that. And perhaps that goes with the positive drug test you put in your letter, that they have the right to a second drug test on the original sample. And then the other part of that statute, which I didn't put up there, just states that you have to use accepted medical testing, which is fair enough. It has to be probative. The other thing this does now, with regard to trying to show that in conjunction with, is that the statute now says a positive test creates a rebuttable presumption. So it puts the burden on the employee now to show that the drug was in his system, that the drug in his system at the time of the accident did not cause the injury. So it's not perfect, and we're not sure how that's going to be interpreted, but at least now it's their burden. The presumption is that it was in conjunction with. So now the employee is going to have to come up with evidence, a preponderance of the evidence to say, no, it didn't cause the accident, or it wasn't contributing to the accident. So that's a positive too. So getting back to Mr. Black, Nancy?
And if I could just butt in real quick, and I'm sorry.
Sure.
The backstory on the accident here is the accident happens, he's in and out of consciousness, he's taken to the emergency room, in and out of consciousness. He arrives at the emergency room. They put him in a room, it's a busy day. He's fed up with it, he walks out. He goes back to the pizza joint. They find him there later, passed out. They get him to the hospital again. Back to you guys.
Right. Okay. So no nonsense. Do you now know everything you need to know about the new drug?
Oh, more than I wanted to know.
Okay. So my questions to you, when we're looking at whether we have the right to take this 50% reduction that the employer wants to take is, did we test Mr. Black within 24 hours of the accident?
Yes, we did.
No, we didn't.
No, we did not. Okay. No, we did not.
Did you not just hear the setup?
No.
Okay. No nonsense.
I was busy getting
just-
ready for a claim review.
You're just okay. Then we're kind of screwed basically. But let me go on to the next points.
Okay.
When did you get the results on your desk? When did you receive notice of the positive drug screen?
It was within 14 days.
Wait, you've had them for 14 days, or?
Well, I didn't know I was supposed to give them to him. I thought the pizza man was supposed to give them to him. Papa John was supposed to give them to him.
Okay, so you have not advised Jack of his positive drug screen,
No, he has not been advised of
and
same.
you've had the results for more than 14 days.
Yes,
All
because I
right.
didn't know that was the way it was.
Okay. Did you give Jack the opportunity to do the second test?
No.
All right, and my advice to you is do not take the penalty. We're not going to prevail on that, unfortunately.
Well, that's a bummer.
Yeah.
Okay.
But the takeaway on this, Nancy, moving forward, is that, let's make sure that drug test gets done right away. Let's make sure that the original sample is preserved, which if you're using standard testing, it is. Let's make sure you turn over the results as soon as you receive them and give them the opportunity to do that second testing. And then let's also remember, with that rebuttable presumption, we don't know what the court's going to consider to be a preponderance of the evidence. If you have a credible claimant and he or she is testifying, I didn't use it, I used it on a Wednesday, the accident happened the following Monday, that marijuana had no effect on me, is that preponderance of the evidence? So I think what's really important also is if you have someone that's suspected of being under the influence or test positive for a drug screen, to make sure that you interview witnesses, get their statements, anything that can help bolster our side that this individual was potentially under the influence when this accident happened is going to help. Okay?
Okay, well, I got another one for you.
What's that?
I got the police report back.
What does the
Yes.
police report say?
It was a little ambiguous as to who's at fault. It looks
Okay.
like he tried to beat the yellow, but he was T-boned, so it's a little ambiguous. But the good part is, it shows he wasn't wearing a seatbelt. I want a 50% penalty.
Is that right?
So that's what you got to do.
Okay. Well, interestingly enough, when I took Mr. Black's deposition, he testified he always has his seatbelt on.
He's a liar. You can't trust somebody who smokes pot.
He testified. Don't trust yourself, huh? He testified that if he didn't have it on, that alarm would be ringing in his car and it would drive him crazy.
Well, that sucks too.
And then the other concern I have, Nancy, is that the emergency room records, as they typically are, aren't real clear. We sometimes get emergency records that show he was a restrained driver on one page, and then 2 pages later it says unrestrained driver. So the ER records are contradictory. But let's look at our potential safety penalty for not wearing a seatbelt, because the police report obviously is strong evidence.
Right, and it's under statute. I mean, you have to wear your seatbelt under the Missouri statutes when you're in the car.
It is Missouri law, you're right, but that's not enough.
Oh.
That's not enough. So if we look at the safety violation penalty under 120, Section 5, it's not enough, and everyone would think that it's enough that you just didn't have your seatbelt on. It's a state law. But what you have to show, and this safety violation penalty can reduce your benefits between 25 to 50%. So it's a significant penalty if you can prove it. But you have to show that the injury was caused by the employee's failure to use a safety device. So in this case, we'd have to show that the fact that he didn't have his seatbelt on caused the injury. He's got a concussion. That's pretty strong evidence. Probably wanted to back it up with some expert testimony in that regard, that but for him not wearing the seatbelt, he wouldn't have hit his head, he wouldn't have had the concussion. We have to show that the employer had a rule to use this safety device. And in this case, it would have to be that the pizza joint, the mom and pop pizza joint, had a rule that all employees should wear their seatbelt. And then we have to show that Mr. Black was aware of the rule, and we have to show that the employer made him aware of the rule. And then we also have to show that the pizza joint, the employer, made a reasonable effort for Mr. Black to use the safety device in this case. So the way you show these things, and this is another, I mean, we are very, the courts are very reluctant to give penalties. The Missouri workers' compensation law is based on a no-fault system. So in order to prevail on a safety penalty, just like the drug penalty, you really have to have your evidence lined up. And evidence that would support a penalty would be, is there written safety materials? What are the chances that the pizza joint has a written safety rule that the employees must wear their seatbelt? I don't know, but maybe they do. But that would be strong evidence that they have a rule. Any evidence of training and education on safety rules would be helpful to back up a penalty. Any warning that a disciplinary action is going to take place if you don't use a safety device or follow a safety rule is strong evidence that the employer made a reasonable effort for them to follow these safety rules. And then sometimes people, you see this a lot in the construction industry, you see that they sign off on their training, they sign off on their educational, that they understand that these are the rules of the company. So that's strong evidence that there is a rule, the employee knows about it, the employer had this training to make sure they're doing it. Things that are bad is if Mr. Black's cohorts say, I never wore my seatbelt and they never did anything. I rode with the pizza joint owner, he doesn't wear his seatbelt. That's going to be the opposite to go to the fact that we're not entitled to a penalty. It's not enough, we have case law that backs this up, it's not enough for an employer just to get up there and say, yeah, we have a rule, yeah, I told him about it, yeah, he knows he should have followed it. That's not going to be enough. So you really have to have this evidence to back it up. Okay, so getting back to no nonsense.
My question is, how in the hell did he get a concussion if he had a seatbelt on?
Well, I think that's a really strong, valid point. I think the police report is a strong evidence of him not having his seatbelt on. Did you have Dr. Head comment on whether or not a concussion could have happened if he was restrained?
I did not do a letter to the doctor, but it's nowhere in his records that I mean, he doesn't say it. I mean, we could ask him that. If it looks like it's going to go to hearing, then we could obviously, you could send him a letter.
Yeah, and I do think that we should do that. Does the employer have a rule that their employees must use seatbelts?
They always tell them to wear their seatbelts.
Okay. Do you know whether it's written anywhere?
No, I do not know that.
Okay. Do you know whether they've ever disciplined Jack or other employees for not wearing their seatbelts? Let's say if they got a speeding ticket, no seatbelt on.
It's my understanding he's been disciplined on several occasions for numerous things, but at least one was for not wearing a seatbelt.
Okay, very good. Do we have anything signed by Jack acknowledging the rule?
No.
Okay. All right. So you want to take the penalty. You want to take the 50%. I say at this point, let's go ahead and reduce his benefits. I would, because it's not strong, I would urge you to stay on the 25%. That 25 to 50% is very subjective by the judges, and you're going to be hard pressed to get a judge to do the 50%. They typically stay on the 25%, unless it's strong evidence that the violation caused the injury.
Those judges screw us all the time.
Any judges in the room? Okay, so let's take the penalty, but no, it's not the strongest, but we can use it as a bargaining chip with Money Miles later on down the road. And let's also get a copy of anything that the employer may have regarding this rule.
Okay, I will ask him. That sounds good.
Okay. The takeaway on this, obviously, is make sure when you have a safety violation that you follow up with the employer to get that evidenced. And I would tell you to do it before you take the penalty, so you don't get yourself into some sort of hardship situation where you don't have the evidence to back it up. So those rules are very important. The penalty is very important. Employers will argue, the reason they have these penalties in the statute is to make the workplace safer, which is exactly why they're in there.
Beth?
You have a question to the right.
Yes.
Would you say it's a good idea to have those safety rules and the employer renews them with the employees regularly?
Absolutely.
Instead of just, once at the time of hire and then 3 years later, so to speak.
Absolutely, because you know what that employee is going to say, oh, I didn't read that and I signed that 5 years ago. They never enforced that. I didn't know anything about it when I signed it. They put this huge book in front of me. So yeah, I mean, I think any employer who is trying to have a safe environment is well advised to have, whether it's monthly meetings or annual meetings, where their employees actually sign off that they acknowledge that these rules are in existence and that they are aware of them. Yeah, that's great. And then the other thing is, while this penalty could be applied to all benefits, we typically in Missouri do not take it off the medical benefits because we direct medical care, and you don't want to, quite frankly, piss the doctors off and have them stop using you because all of a sudden you're only paying them 50%. So we typically don't go that route on the medical bills. Okay. Any other questions?
I got a bunch of text messages in.
Okay.
Go ahead, since you had your hand up, go ahead.
Okay, I'm going to go back to the slide before this one.
Uh-huh.
The employer has to notify the employee within 14 days that we filed this test.
Hold on. Everybody wants to hear you.
Okay, so It's the language actually is the insurer or the self-insured trust has to advise them. So it doesn't say the employer has to advise them, and I think this slide is a little confusing because it does say within 14 days of the employer, but it actually says insurer, and we know the courts are going to look at that strictly.
Well, if I'm self-insured and I have a testing facility that within 72 hours, if they have a positive, has to contact that employee, does that count? Is that notification?
You know, it says the insurer must provide the employee, so I would tell you to make sure it's the insurer or the self-insured trust that is providing that notice to the employee, because we have cases out there before where a nurse went in and requested the drug screen and they denied the penalty because they said the statute says the employer must request the drug screen. So they get really, they nitpick and they you know, that strict construction, they do it strictly. So I would tell you to err on the side of the insurer or self-insured trust actually providing the notice.
Thank
Yes?
you.
In the case of a self-insured, would the PPA qualify?
They would, yeah, yeah, yes.
I've got again, we got a whole bunch of text messages in on this particular topic, one in particular, and I think everybody probably thought the same thing. If the claimant does not report an injury until 2 or 3 days afterwards, should we drug test anyway? Because our policy says we will do drug testing
Yes.
post-accident.
Yes. You certainly don't want to send the message that if you wait 25 hours to report an injury, you're not going to be drug tested. Employees aren't aware of this. You know, they're not out there saying, you know, they wait because they hope it's out of their system.
So then you may not have, anything to take on the comp case, but you may have a situation where you've got post-accident misconduct all of a sudden.
Well, I don't know, Steve. I think, and we'll get to post-injury misconduct, but I think.
But if you got a positive drug screen 2 or 3 days after the accident,
Yeah, it's done in conjunction with the accident. I think a judge is going to say that's part of the accident, it's not post-injury. But perhaps, I mean, I think there's an argument to be made. But more importantly is when you have these rules, you apply them consistently. So if your rule is that you drug test every employee post-accident, then you should do it. You shouldn't just say, oh, it's been 25 hours, so we're not going to do it.
we're going to hand the microphone over to Maria, and she's going to give us a little quick case law update before our break.
Judge me on my ability to stick this microphone back in the stands. My name's Maria Doherty, and I'm a senior associate with Evans & Dixon. Disclaimer, case law updates will not be as dramatic as the awesome play that's going on, but I'll try to keep them as exciting as possible. So my first case is Lincoln University versus Narrans. This is a 2016 Court of Appeals Southern District case that looked at compensability and whether an injury arose out of and in the course of employment. Now, one of Beth Schock Legal's first questions is, are we sure this is arising out of and in the course of employment? Are we questioning compensability? It's oftentimes one of our very first questions when we get a file referral because it sets a lot of actions in motion if we are choosing to deny compensability. So the facts in this case, the employee was walking down a sidewalk. On the left side of the sidewalk, there were cars that were kind of, their bumpers were overlapping the sidewalk. And on the right side, there was a very steep edge before it cut into the grass next to it. Along the right side of the sidewalk, there's worn grass paths, indicative of the fact that people were using the side to the right of the sidewalk to actually walk. On the date of the injury, the employee was walking to the parking lot, done with work for the day, when a group of students was walking towards her. So she stepped to the right to allow them to pass, and when she was doing that, she slipped off the right side of the sidewalk, bumbled around, and then ended up breaking her left ankle. There was also testimony that prior to this actual accident, while she was walking with her supervisor, the supervisor similarly injured herself falling off the same part of the sidewalk and injured her knee. So the employee was successful at the ALJ and the commission levels in obtaining benefits. The employer, of course, appealed these decisions. The ALJ found nothing to suggest that the cause of the fall was anything other than the condition of the crowded sidewalk and the edge of the sidewalk. The court ultimately found that this daily exposure to this location and the condition of the sidewalk involved was an increased risk of suffering an injury-producing fall, to which employee was not equally exposed in her normal non-employment life. Employer made several arguments, one of which was that the proper risk source was walking, and thus it was not compensable because she was equally exposed to walking, being she's a Homo sapien, outside of work. In this argument, they attempted to liken the facts of this case to Miller and Jomey. Now, many of you may know about Miller. It was the case where the gentleman was walking towards his work truck when, out of nowhere, his left knee popped, causing an injury. Benefits were denied in that case. And Jomey was the case where the employee slipped and fell off of her sandal and it caused an injury. Benefits were also denied in that case. The court distinguished this case and found that the employee in Narins was injured as a result of an unsafe condition that she was exposed to due to her employment. To do this, they identified the risk source or the activity that caused the injury and then compared that risk source to her normal non-employment life. Ultimately, they found that walking itself wasn't the risk source, rather the risk was stepping off of the steep edge of the sidewalk, and she was not exposed to that particular risk outside of the workplace. Another argument that the employer made was that the injury was not compensable because she was leaving work for the day, and she was not doing anything work-related when she actually fell. The court rejected this argument because the employer exercised sufficient control over the premises where the injury was involved, which they found satisfied the extension of premises doctrine. The takeaway from this case is the fact that an employee is not performing their job duties at the time of the injury does not necessarily preclude a finding that the injury is compensable if they were exposed to a risk or hazard that they may not have been exposed to outside of their employment. Or in short, if you have a faulty sidewalk and people keep hurting themselves on it, probably should get that regraded and fix it up. My next case is Campbell versus Trees Unlimited. It deals with an idiopathic event that was argued by the employer. This is a Court of Appeals case from 2016. This case involved a one-vehicle crash where the employee was the only occupant of a vehicle and died from his injuries. The ALJ and the commission found this to be a compensable injury. A witness who saw the injury, the accident happen, testified that he was a couple cars behind him. He saw the car switch from the right lane to the left lane into the median, and it didn't appear at any time that he put on his brakes. The car also appeared to maintain the same rate of speed while it was traversing into the median. Then the witness testified that he saw a puff of dirt, smoke, and he saw the vehicle launch into the air and disappear into view. Being watching this, he followed the car to figure out what happened to the truck, what happened to the driver, and he saw where the truck had left the ground and went down into a ravine and stopped. There was evidence that when the employee's arm was cut as a part of the accident, there was very little blood. And based on the type of injury it was, there should have been a lot of blood. Now, this led the employer to argue that perhaps an idiopathic event caused the employee to die of unrelated reasons, and this is what actually caused the motor vehicle accident, which would take it out of compensability. But the ALJ found that the evidence supported quite the opposite, that he was in good health, he was active, and he had not indicated to anyone that he had any sort of medical complaint prior to the accident. One of the arguments I wanted to bring to light today is this idiopathic event argument. It's an affirmative defense, and the court defined idiopathic as peculiar to this individual, innate. Essentially, some underlying medical event peculiar to this claimant that we could point to have caused the accident in this situation. The court focused on the testimony of the competing experts that discussed the employee's reaction time, his medical or mental incapacitation while driving the car, and ultimately, the court found that there was not enough medical evidence to support a finding that a sudden medical event could have caused the incapacitation before the crash. There was also no medical evidence that the employee was peculiarly susceptible to a sleep disorder or an inattentive disorder that could have caused the crash. The court ultimately rejected the affirmative defense of an idiopathic condition, and the Court of Appeals found that the commission was entitled to do so based on the testimony of these witnesses. The takeaway from this case is that the employer must be able to identify a sudden medical event that could have caused the work injury. Circumstantial evidence, all of these varying opinions as to what could have occurred or theories of what kind of sudden event could have occurred, they were insufficient. Relating this back to our fact scenario, what if Jack Black had an idiopathic event that caused the crash? How would that play out and affect compensability? How would that affect the civil claim? The Campbell case is telling us that in order to have a successful idiopathic event defense, we would have to identify the sudden medical event that could have caused the accident that led to his injuries. It would not be enough for us to say, or allege in general, that a heart attack, it could have been a sleep spell or a seizure that caused the accident. We have to be able to more finely tuned point to a reason that would have caused the accident. My next case is Morris versus Captain D's and the Second Injury Fund. This is a 2018 case. It involves an award for future medical. Now, something we try to avoid at all costs if possible is this award of future medical, because it's out there, it gets costly, and who knows if there's an end in sight to it, right? At a minimum, when we have our doctors testifying as to future medical, we try to get them to finely tune any recommendations for treatment and have them be specific as possible for future medical related just to this work injury as opposed to any other possible conditions that are out there for this claimant. And just a little bit of a teaser for Act 2 to get you excited. I expect that Jack Black in our scenario will be making demands for future medical with regards to pain meds. So Morris involved 2 work injuries. In January 2007, he had a car accident, and then a couple weeks later, he had a slip and fall where he injured his neck and his low back. Prior to the work injuries, he had pre-existing injuries to his right knee, his back, his neck, chest pain, high blood pressure, heart disease. I mean, we've all seen these cases before. We know where this is going, and it's not going in a good direction, right? So he ultimately ended up having a fusion at C5-6, C6-7, followed by physical therapy. By May of 2010, he had been involved in 2 additional rear-end collisions causing injury requiring additional physical therapy. This guy's either got the worst luck ever or he's a terrible driver, but regardless, this is a situation that we sometimes come across. He was subsequently diagnosed with a new large disc herniation at L4-5, where he underwent a laminectomy with a discectomy. When he was seen by his rating doctor, one of our favorites, Dr. Villarch, in 2012, Dr. Villarch opined that he was permanently and totally disabled. He also recommended ongoing care for his pain syndromes, including epidural steroid injections, foraminal nerve root blocks, trigger point injections, TENS units, radio frequency ablation procedures, and consideration for a spinal cord stimulator. I mean, that list alone, you should just be seeing dollar signs because...
Don't forget hot moist packs.
Yes, well, so I mean, those list of recommendations, those are expensive. You don't know how long that type of treatment's going to go on, and so as a defense attorney, we're trying to cut that off. Dr. Villarch also felt the claimant would require chronic pain management, treatment of his neuropathic pain with oral medications, a long list of things. But when he was asked in his deposition whether these treatments were directly related to the work injuries, to the low back and the neck, Dr. Villarch testified that no, they were not completely related. Claimant had the injuries to his neck, his back, he had the subsequent deterioration, he had a couple car wrecks, and so this general list of recommendations was a mixture of his subsequent problems as well as all of his pre-existing issues. Ultimately, the ALJ and the commission awarded the future medical treatment, this long list of costly treatments, to the claimant. The employer argued that the award was not supported by the substantial and competent evidence because he had significant pre-existings. He had all these subsequent car accidents. You can't tell me that all of this is related to our work injury. The court, although found that Dr. Villarch's recommendation for future medical was related to a mixture, it didn't matter. They were going to award it. They affirmed the award of future medical because they opined that the claimant demonstrated a reasonable probability that future medical treatment was needed for this work-related injury to his neck and his back. Dr. Villarch consistently recommended the ongoing care for the pain syndromes, and the court declined to hold that more specific or conclusive evidence of exactly what treatment is needed for which injury was required. So the takeaway from that is that it exposes the employer and insurer to increased liability for future medical care. We can be on the hook for future medical, even if the future medical treatment targets these pre-existing injuries or subsequent conditions. I mean, we see this a lot. You've got someone who's got multiple lower back injuries. They've been taking Vicodin and Percocet for years by their primary care physician. They get injured, and even though they may have only used it temporarily with our work injury, we may get an award for future medical, even though they've been taking the Vicodin and the Percocet for years before. So certainly something to consider when we have our doctors evaluate and make recommendations for future medical treatment. I'm going to skip my next case, Burleson versus Department of Public Safety. This is just it was a 15% increase of benefits under Section 287-120. Beth did a really good job of explaining how difficult it is to really succeed in trial with a safety violation. So we're going to skip over that one because I think we're a little short on time. So my next case is Cosby versus SIF, and this is the slide I need. It's a 2017 commission case, and the findings of the commission aren't really of relevance to us so much as the dicta in the case that has given us some red flags as to how liability that used to be the responsibility of the second injury fund may in the near future be transferred to the employer. As you may know, in 2013, the legislature overhauled the second injury fund to try to refund it, as they were in the red for quite some time. They had thousands of claimants not getting paid their owed benefits, and changes had to be made. And one of these changes was getting rid of permanent partial disability cases after January 1st of 2014. Now, a quick lesson on the second injury fund to give you a mathematical framework. I'm a visual person. If we can go back to that slide. Thank you. So say someone has a prior sprain or strain of their neck for 10% of the body as a whole. That is 40 weeks based on the 400-week level. Then they have a subsequent work injury that's settled against the employer. We've accepted compensability. This is 15%. This is what we think it's worth. That is 60 weeks. Combined, that total disability is 100 weeks. So the second injury would pay a load based on this combination of the fact that not only does he got a bad neck, now he's got a bad low back. They would pay a load between 10% and 20%. It just depended on the type of body parts involved, if they were opposing extremities, that. So if the combined number was 100, SIF typically would pay on an injury like this, 10%, 10 weeks of disability. That's what we're referring to when we talk about this extra SIF liability. Having given you that framework, we can go to the next slide. Cosby versus the second injury involved an ALJ denying benefits to an employee for permanent partial disability because the 2013 amendments indicated that no claims for PPD occurring after January 1st of 2014 shall be filed. In the case, employee had a primary injury that occurred on January 22nd of 2014, and as such, any claim he filed would not be allowed for permanent partial disability under the statute. The guy in this case also had a list of prior pre-existing conditions and also failed with regard to permanent total disability. The judge just didn't think that he was PTD, and so he was out of luck. He got no benefits for PPD or PTD. Now, the reason we highlight this case is the language used by the commission indicating that the 2013 amendments to the 287-220, that's the SIF statute, work the effect that the employers and their insurers are now liable for any enhanced PPD that results from this synergistic combination of pre-existing disabilities and primary injuries occurring after January 1st of 2014. So that 10 weeks, that SIF liability that used to be the SIF problem, that case stands for the fact that, I mean, it's dicta, it's not the holding, but it stands for the fact that in addition to that 15% we paid for our compensable work injury, we might also get hit with that 10 weeks of extra disability that would have normally gone to the SIF. The commission indicated that in making the changes to the statute, getting rid of the SIF, they thus removed from employers the prior protections of the second injury fund for these kinds of synergistic injuries. Now, this is the scarier part. By the same token, the commission said that an employer is liable for any claim of permanent total disability resulting from the combination of pre-existing disability with a work injury where the facts and circumstances do not satisfy the new and more rigorous standards set under 287-220. So prior to January 1st of 2013, the employer would be, or 2014, the employer would be liable for PTD benefits if the last injury alone resulted in the claimant's permanent and total disability. The second injury fund would be liable if this person has all sorts of pre-existing conditions that combine with the work injury to render them PTD. But after the changes, any work injury occurring after January 1st of 2014, there's only PTD available, excuse me, but the employee must have a medically documented pre-existing disability equaling a minimum of 50 weeks of PPD, which is a direct result of active military duty, a direct result of a compensable injury in the workers' comp, or if not, from a compensable injury, must directly and significantly aggravate or accelerate the subsequent work-related injury. We don't know what that means yet. That hasn't been interpreted by the courts, but it seems pretty stringent. The other way is if they've got a prior PPD of an extremity, like the left arm, and then the actual work injuries for the right arm, and then combined, that makes them total. As a firm, we're starting to see claimants bar cite this commission case when they demand additional weeks from us in light of pre-existing injuries. We're also seeing the claimants bar demanding PTD from us when they don't think they can be successful, alleging it is owed from the second injury fund under these new stricter standards. We're aware of at least one doctor incorporating this Cosby language into his rating reports. He does the math and he says, well, it basically gets rid of SIF and says there's an additional disability, and I think the employer is probably liable for it. I spoke with a SIF supervisor yesterday and was told that this Cosby case is actually, it's been appealed to the Court of Appeals, briefs have been submitted, and they are awaiting oral arguments this month. They expect that they'll happen this month, if not this month, the next month. And so this is real live time happening now. I'm sure this type of case is going to have a significant impact on employers and insurers for both partial cases and total cases going forward. To end on that really super cheerful, happy note, I won't want to end on that, so I'll go on to say that all of our cases, we do a monthly case law update. We add it to our website. If you want to be added to a list that gets these monthly new cases sent to you, then talk to your attorney, talk to me, happy to add you. And having said that, I'll send it back to Steve.
And it's also, it's a link on the website, correct?
There's a link on the website, yes.
And it's a fluid document, meaning it changes every month as new cases come through, correct?
Yep.
And I will tell you from personal experience, I have seen these demands at mediation. I have seen this enhanced PPD at mediation. I have seen attorneys argue that case. Down at Cape Girardeau, a couple of judges were like, what are you talking about? I'm not sure. But it's starting to creep up. And I know there's a doc down in Springfield that is actually writing reports to that effect. You know, it's weird to see the doc doing the math and basically saying, well, the second injury fund isn't liable for this, but I think there's additional benefits here. So it's something that we're going to see. So hopefully the Court of Appeals does right by us. Let's take a break, about 15 minutes. I'll call you all back in, and then we can finish this up. All right, to the right of me is Bill Lamson. Bill, wave. Bill's in our Omaha office, and he handles Iowa and Nebraska. And he's here today, and I wanted to at least point him out. If you folks have cases in Iowa and Nebraska, Bill would be happy to help you out, answer any of your questions. Again, if you had a question about how today's scenario maybe plays into those other venues, he'd be the guy to ask. And then we got Brett Jepson with our Kansas City office. He does both Missouri and Kansas. And again, I was going to do the same thing with him and ask him about how our scenario would factor out in Kansas. He is here if you would like to ask him any questions, and if we have any time at the end, we'd be sure to hit him up as well. And then we have Mike Carr. He is one of our many Illinois reps here today. At least I had him up here in case we had any Illinois questions based upon the current fact pattern. And I guess the predominant wisdom is Illinois is...
We're going to lose.
There you go.
Just start paying benefits.
Yeah.
Just start paying benefits.
Yeah. And at the end of the case law update from Maria, we had a couple questions about autopsies. And I wanted to let Maria at least address that along with Jim Kennedy, one of our partners.
Thanks, Steve. Welcome back. So one of the questions was in my Campbell versus Trees Unlimited case, the vehicle car crash with a motor vehicle accident where the gentleman died. Was an autopsy ordered, and can the employer and insurer order an autopsy? I've got the case with me. An autopsy was not ordered. The examination that happened at the scene was just that it was apparent that there was internal organ damage, the sternum was crushed, the ribs felt as though they had been torn loose, and there appeared to be no support for the chest. They also drew, for the chest, excuse me, and they also drew a toxicology sample at the scene. Now, I will have Mr. Kennedy discuss a little bit about death benefits and the availability of autopsies in workers' comp.
There are a couple of statutory sections that deal with postmortem examinations and autopsies. First of all, under Missouri law, I believe that anytime you have an automotive fatality, there has to be a postmortem done. There's been some issues over the years whether or not that report is admissible on its face or whether that is simply done to track the circumstances of auto fatalities, such as whether there's drugs or alcohol involved. The work comp law, section 287.210, which is the section that deals with the right to a medical examination, has two sections that deal with autopsies, and one provides that wherever an employee is killed on the job, that there shall be a postmortem examination done, and that the coroner is obligated to identify alert the employer and the dependents of the deceased of their right to be aware of the autopsy. It makes that report admissible, and it also gives the parties the right to cross-examine or examine the coroner. The other section, 287.2109, says that the division or the commission may, in extraordinary circumstances, order an autopsy and, for that purpose, have the body exhumed. Now, what we don't know is what is an extraordinary circumstance. Presumably, the employer would, or an insurer would have a right to file a motion with the division or the commission and requesting an order be issued to have the body exhumed. Now, I have not seen that done in recent memory, but the statute is there. It's been there for as long as I can recall. But you have to have a pretty extraordinary situation, in my view, to get the division, and they would probably boot it to the commission to grant an exhumation where the family objected. You could see where there were circumstances involving maybe a possible sudden cardiac event or a drug situation that you might be successful, but there is that right at least in the statute. So in a given case, you could try that method of discovery, but good luck. Thanks.
Thanks, Jim. Well, back to our scenario with Mr. Black. 2 months have gone by. Jack is non-compliant with his treatment. I know. He appears to be fond of the pain pills that they have been prescribing. The medical provider has released him to light duty. The employer is adamant that Mr. Black is dealing drugs out of the shop. Make sure your mics are on.
Yeah, but before we get started, Mr. Brogeman asked me to please get you all back engaged. So Nancy's going to do a little dance number. And
Right. I can barely do this. Are you kidding me? Oh, Lord. Oh.
Okay.
Miss Shock Legal.
all right, hit it, Nan.
Okay. Ring, ring, ring.
Elizabeth Shock Legal.
Hello, Miss Shock Legal. It's No Nonsense Nancy again. How are you?
You again?
Yes, me again.
What are you calling us?
I'm calling you with reference to our local pothead, Jack Black.
Is this the only case you have?
Excuse me, I have 400 cases. Is that about right, guys? All right, maybe 280. But I
So
have a lot
what's
of
going on
cases.
with Mr. Black now?
Okay, it's really getting bad. I have a couple issues, but the employer swears up and down that he's dealing drugs, and they want to fire him for post-injury misconduct. Is there something we can do?
Okay, so why are they convinced he's dealing drugs?
Because there's all these little cars that are outside his apartment. I don't know why they're little cars, but there's cars that are outside his apartment at strange hours. And he's driving, he got a brand new Cadillac now, he got another one, and so there's no way he's making that kind of money selling pizzas, delivering pizzas.
All right, so does the employer have proof that he is dealing drugs other than the little car argument?
No.
Is he selling them to clowns?
No. No, there's no police. They've never called the police. There's no police report. This is just a supposition that they have. And so they called and they said, "What can we do?" And we want to see if we can terminate him for post-injury misconduct.
Okay, is there anyone at the employer that Mr. Black has told that he's dealing drugs?
No.
No admission by Mr. Black?
No admissions.
Okay. Do you want to go down there and try and buy some drugs?
Sure.
Wait, have you gone down there and bought some drugs?
I'm not past a little. No.
Okay, all right, so the employer wants to fire him on this speculation that he's dealing drugs under post-injury misconduct. So we look at 287, 170, Section 4. This is a provision that if an employee is terminated from post-injury misconduct, that he is no longer entitled to temporary total disability or temporary partial disability benefits. In other words, but for his misconduct, he'd still be working there, or he'd still be unable to work there, and we'd still owe him benefits. Post-injury misconduct does not include an absence from the workplace due to his injury. So if he's missing time because of doctor's appointments and he can't do his light duty, that's not post-injury misconduct. In order to really use this statute as it's intended, it really has to be something separate from the accident. In Mr. Black's case, again, we don't have any proof of it. And if we go and terminate him on this speculation, we could be opening the door to some additional liability. Employers in the state of Missouri think that the statute is designed to, punish injured workers from misbehaving. And employees, on the other hand, say, this is a no-fault system, and you shouldn't be punishing me because I'm doing something. They tend to say it's because of the accident. So you really want to make sure that it's truly misconduct and it's truly not related to the accident. Because think about that, if it wasn't, what could the employer do? The employer could just fire everybody that's injured and not pay them. So you got to make sure you have your evidence to back up, and it has to be a legitimate reason for termination. What the statute doesn't do is define what misconduct is. So that's up to the courts to decide if it rises to a level of misconduct. And earlier, Steve mentioned the drug testing, and I've had people, I know people who have argued before the judge that a post-accident drug screen that's positive is post-injury misconduct. And judges say, no, that's related to the accident. You're drug testing because of the accident. That can't be considered misconduct. Maybe a random drug test, 6 months later, would that be considered misconduct? Probably. There's other cases out there. One of the judges was telling me about, he had a case where they argued this person was working the front desk and was cursing at their customers. And, the judge in this case did not find that particularly offensive, but he understood the employer's position that you can't have somebody up there, cursing out your customers. So I think that I don't know how he ultimately ruled on it, but I think he was leaning towards finding that to be misconduct. I had a case where someone keyed their supervisor's car. Police came, we fired him, clearly misconduct. The employee's attorney argued that that was not misconduct, and the judge said, come on, you committed a crime, you have a police report to back it up, they don't owe benefits. So you just want to make sure that, you have proof of the misconduct, that it's truly misconduct, that it's not related to the accident. And another thing that the case law has come out and said is that misconduct is not simply, you aren't meeting our expectations. That's not going to be enough. So, an employer better be able to point to something pretty significant that is misconduct in order to get the benefit of this statutory provision. And the other thing that's good, again, evidence, is, were they ever warned about this conduct? If so, was it written? Did they acknowledge it? Those are things that are going to help back up this statute being effective in a case. So back to Mr. Black, no nonsense. We don't have any proof, right?
Right.
It's just speculation. So unfortunately, I don't think that we're going to be able to prove his misconduct. Now, if something changes and the police, are called and it's proven that he is dealing drugs, then it's a different story.
Isn't there any way to get rid of this little twit? Okay, all right.
What's the status on his treatment?
He's been released to light duty, and he's taken a lot of pain pills. Now, mind you, our doctor does still have him on a few pain pills, but
opioids?
Yes,
Yeah.
Like a little bit of OxyContin.
Just a little bit.
Just a little bit.
Yeah.
Okay. But he is released to light duty, but he's given restrictions of no driving. And so the employer does have cash register work for him.
Okay, so he's a pizza delivery guy, no driving. All right, so they're offering...
Cash register work.
Okay.
We have one more problem.
Of course we do.
He's dyslexic. So,
Dun, 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 dun.
So he can't use the cash register.
Where is this cash register from? Like 1920s?
Somehow the cash register doesn't work.
Okay.
So.
Well, it's interesting that you bring that up. We do know he's dyslexic. When I deposed him, of course, I asked him all about his pre-existing issues, and dyslexia was brought up, and he has proof of the testing back in middle school, and so we know it's a legitimate learning disability that he has. Is that the only job they have for him?
Well, yeah, but he's refused light duty, and so can't we just, this should be something that's a no-brainer. We should be able to cut off his TTD, right? He's refused light duty.
Okay, my gut instinct is yes, but here's the scenario we're faced with. The question is, does an employer have to accommodate a pre-existing disability in consideration of light duty availability?
You just come up with one roadblock after another, don't you?
I'm just doing my best here, Nancy. What I would like to do before we make a decision on this is contact my partner, Jerry Richardson, who does employment law, and pose this question to him because he would have some insight on this issue as to whether this employer has any obligation under federal law or state law to accommodate Mr. Black's pre-existing dyslexia.
Okay.
Let me conference him in and see if he's in his office.
Okay.
Yeah, conference me too, so I can listen.
No, we only have two. You can only have two people on a call. And I don't even know how to do that. So I should say, if I hang up on you, I'll call you right back. All right, Jerry.
Beth, how can I help you?
Yeah, Jerry, I have a client on the phone, one of my favorite clients, and we have a situation that's a little unique. We have an employee who's sustained a work-related injury. He has finally been reduced to light duty. The only work that they want to cut off his benefits, obviously, but he's refusing to do the light duty because he claims he can't do cash register work, which is the only job they have for him, because of pre-existing learning disability of dyslexia, which we know he definitively has. Is there any obligation for my employer to accommodate this pre-existing disability in this scenario?
Well, first, what are the nature of the injuries that he has?
He had a concussion, and he's a pothead, and he's hooked on pain pills.
Okay, if I translate that, he had this head injury, and he also has some ongoing, at least medication issues. Does the medication that he's taking, does it affect, for example, his ability to drive if he was a pizza driver?
Well, he has a restriction of no driving, but that's not due to the pain medication that he's abusing. That's due to his concussion. So that's the reason for the restriction on the driving.
Well, the duty to accommodate is to the job that he has. That means the driver job. So if you cannot make some kind of accommodations to that job, and you never have to do anything that would eliminate essential functions. But in any case, you can, if you have for example, in your case, with workers' compensation, you can use a light duty program, but that can raise a couple of other issues. One is if you have a program and it doesn't have limits on it, you could end up putting someone in light duty, and that becomes that person's job for ADA purposes as time goes on.
So in other words, if we start to accommodate a pre-existing disability, that could morph into an argument that that's his new position.
Depending on how you're light duty, you don't have to have light duty from an ADA standpoint, but if you do, you have to be aware that there can be some unintended consequences if it just can go on forever. If you have some limitations on light duty, and for example, it is all right to have a distinction that for workers' comp there can be light duty, but for a non-work related injury, for example, an employee that has a heart attack and when facing coming back says can't do certain job functions, there's no light duty requirement just because it's offered to work related injury people. So these are all complicated issues. So in any case, it sounds like you're saying he can't do the registrar's job because of the dyslexia.
Correct.
So that you're in a situation where if you're going to do anything with someone with a disability, you have to see whether the person can meet the minimum qualifications. The minimum qualifications of the light duty position would be operating the cash register, which he cannot do. Is that correct?
That's correct.
So you can't put someone a 4-foot person in a position and say you must be 6 feet tall. And you can't say, well, you got to try harder. That's just not going to work. All right, that's going to end up being disability discrimination. Now, you could have an issue with also the FMLA, depending on how many employees the employer has. FMLA is Family Medical Leave Act. How many employees are we talking about?
Jerry, this is just a mom and pop pizza shop, but I'll have no nonsense answer that. Are you aware of the number of employees they have?
I think there's about 12, most of them being kids that deliver the pizzas.
Since there's less than 50 employees, you have no FMLA issues.
Yay.
So I won't even go into that. But in any case, it sounds like the position is really not a reasonable accommodation under these circumstances. So if you can come up with another position where the dyslexia doesn't limit the person's ability to do the job, that would work.
But what if we don't have another position in this case, and we are treating it as he's refusing the light duty we're offering? And typically in that situation, my advice to the client would be to terminate his temporary benefits because he's refusing light duty.
Well, at least from an ADA perspective, you're taking someone who's 4 feet tall and you're saying you must be 6 feet tall. And if you're not 6 feet tall, we're going to discontinue your benefits. I think you're creating liability under the ADA or under the Missouri Human Rights Act, either one.
Okay. Thank you, Jerry. No nonsense, does that answer your question?
Yes, it
We
does.
got to keep the pothead
it.
for a while. Okay, and see if the pizza joint can come up with an alternative light duty, whether it's
Busing or something, perhaps he can do
sweeping,
that.
mopping.
That's assuming he has all 4 extremities, I guess. I mean, who knows what he's going to have next? I mean, anyway, go ahead.
All right, okay. And the takeaway from this is when you're faced with a strange situation like this, it's really important. I mean, we're your first line, but at Evans and Dixon, we have the backup resources in the expertise and the employment background to pose these questions, you know, sometimes the very same call, like we demonstrated here today. Questions? Steve?
Steve?
I'm looking.
2 months later.
No, not yet.
Not
Not yet.
Not
She
yet.
is
Not yet.
like, no.
Moving ahead,
months.
3 months.
3 months, 3
Thank you.
months.
Thank you.
All right.
Jack Black has been back at work now, normal job. However, there have been some concerns.
Ring, ring, ring.
Elizabeth Shack, legal. This better not be no nonsense on the Jack Black matter.
It's me. Yes, it's me, and I'm calling you on good old Jack Black again.
All right, what's up?
Okay, now all hell's broken loose. He's been he's back to work. He's back to driving. He's been high as a kite at work. He's on pain pills, and he's on a lot of pain pills. He's fallen twice with 2 concussions. Now he's saying he hurt his knee. The employer said that he overdosed and they had to send him back to the emergency room, and they tested him and he had a high amount of opiates in his system. Now, our doctor is giving him a little bit, you know, he's still on a small dosage of OxyContin, but I'm getting like tons of bills that are coming in for unauthorized treatment from this pain med guy, Dr. Feelgood, and I'm not going to pay him, and I don't know what to do. And he's also posting stuff on Facebook. This kid's just a wreck.
Okay, so I did note that when you sent me the bills, they were from various ERs around the area, and it does seem like maybe he's drug shopping, pill seeking. So we're not paying those bills, right?
Correct.
Okay.
No way.
So my first concern, and no nonsense, you've had these cases in the past where an employee gets into a situation where they become dependent on pain medication. And you're aware of the opioid epidemic that's going on in our country, and especially in our state. So I'm concerned about that because those cases go south pretty quickly. And when you're telling me he's overdosing and so forth, my concern is, well, what if this kid dies? And then what if the argument is that we were prescribing him pain medication and he dies, and then it becomes, you know, a death case for us. So that's concerning to me. What is this Facebook stuff?
He's basically bashing the employer on Facebook. He's said that they're being real jerks, that they're kind of discriminating against him for filing. He called it discrimination. That they're for filing a comp claim, and they're just harassing him, and so he's got it posted all over Facebook.
Okay, and so what do they want to do with?
They want to They want to fire his butt. They want to get rid of this kid once and for all.
Okay, so when you say he's posting stuff, is it stuff like, my job sucks, my boss is treating me like crap because of my injury, and my boss is such a jerk, who does he think he is?
That's exactly what he's posting.
I'm one of the
You're omniscient, girlfriend.
I'm one of the 20 likes. Okay, Nancy, so again, before we tell them to go ahead and terminate him, I want to at least touch on and make sure that we're aware of, you know, the statutory provision, 287-780. There's new changes to this section as well in Missouri as of last fall. So a little history on this. This is the section that says if an employee is discriminated against or terminated because of his or her exercise of their rights under work comp, that they have a civil cause of action against the employer. So when we look at the history of this section, the original language was that an employer shall not discriminate against an employee for his or her exercise of their rights under work comp. If they do, they have a cause of action, right? Discriminate or discharge. There was no mention of what the standard of proof was for that employee to prove that that discrimination or termination arose out of their exercising of their rights. So case law, this is old law, case law had interpreted that as an employee had to show that the exercise of his or her rights was the exclusive factor for the termination or discrimination. That was a pretty high standard. So you didn't see a lot of plaintiff's attorneys arguing 780 if their client was terminated, because typically if you're going to terminate someone, you have something more than just they filed a claim or they got hurt. So under that old scenario, employers were pretty protected, and they weren't that scared of getting rid of employees. Then in 2014, injured employees, I should say. In 2014, along came a case of Templemeyer, and the court changed the standard. The court said, wait, there is no exclusive factor language in the statute. And they interpreted it as meaning that Templemeyer came along in 2014 and changed the standard and said all the employee has to show is that his or her injury or the filing the claim was a contributing factor. So that was a very low standard of proof. I mean, if I'm the employee that's getting fired and I cursed at people and I posted stuff on Facebook and, you know, I slapped my boss across the face and I have a work comp injury, all I have to show is, well, it played some factor in it, the fact that I was an injured employee. I didn't have to show that it was the only reason. I just had to show that it was one of the many reasons. It was just a contributing factor in my termination to have a cause of action. So that made employers, rightfully so, a little skittish about terminating employees during the course of a pending workers' compensation claim. Fast forward to 2017, the legislature came in and changed the standard within the statute. So now the statute reads that an employer cannot discharge or discriminate against an employee for exercising his or her rights under work comp, but it adds the requirement that the exercise of the rights must be the motivating factor in causing the discriminatory action. And then it goes on to define motivating factor, and motivating factor is defined as the exercise of the rights actually played a role in the discharge or discrimination and had a determinative influence on discharge or discrimination. What, right? So we don't have cases yet that I'm aware of that have come out that are interpreting this completely, although that motivating factor language is more in line with the federal standards. So turning back to Mr. Black, who has posted this stuff on Facebook, the concern is if we terminate him, are we going to find ourselves in a position where 780 is being alleged? So Nancy, before we make a decision here, let's get Jerry back on the phone and run this scenario by him and get his input. Do you have time for a conference call?
Yes,
All
I
right.
always have time for you.
Jerry?
Beth, how can I help you?
Well, remember when I called you about the accommodation issue I had with a client?
I do.
So I have that same client on the phone, and we have a new scenario with this individual. The employer now he's back at work full duty, but the employer wants to terminate him because he's been posting some negative stuff about them on Facebook. You know, my concern is that some of these Facebook posts allude to his work injury, and I just want to make sure that this employer doesn't get themselves into a 287, 780 case, and I would like your insight on it and what you think this new motivating factor standard is gonna have.
Well, that's only part of what your concerns are, but let me address that first. Under the overall scheme with Section 287780 claims and the change of the wording that will be used to establish liability to motivating factor from contributing factor may or may not make any difference. We just don't know at this point. And at least in my experience, trying all kinds of wrongful discharge claims, what really matters to the jury is the jury's sense of, is there injustice to the employee? And where does the injustice in the case come out? Which will mean that employees will win at a similar rate under the comprising to the contributory factor. It was at about a 62% rate when a case went to trial by jury that the employee won. Now, under federal cases that use a motivating factor standard, similar to what this new one in the state is, it's probably more jury trials are 50-50. But either way, most of the employers I work with don't really like those odds, be they 50% of winning or 62% of losing. So that's something to keep in mind on that. With the Facebook posting, you most likely are faced with something that is protected activity under the National Labor Relations Act. There is a provision in that law, and applies to both union and non-union workplaces, and it basically says that employees can engage in protected concerted activity. Protected concerted activity has been interpreted to mean almost anything that involves the workplace, and as long as the employee is just not making a personal gripe. Now, do you know whether there were any comments made to those posts?
I do know that there were 19 comments to the first one and 25 to the second.
I see. Do you know whether any employees were making comments?
Yeah, some other drivers were making comments.
And were they supportive of what Mr. Black was saying?
No, they were more like, dude.
I pay you to represent me in court, dude.
Dude, where's my car? No, they weren't. In other words, he wasn't inciting a riot against the employer or anything, no.
Well, any discussion of supervisors, so if he, for example, was making comments about a supervisor and whether the responses are in favor of those comments or against them, again, that's protected concerted activity. If you terminate an employee under circumstances where he can allege, I've been terminated shortly after doing protected concerted activity, the NLRB will be all over you. And you won't find it to be a, shall I say, pleasant experience. I will say that for an NLRB kind of case, it has to happen quickly. There's a 6-month statute of limitation for the employee to make the complaint. A lot of the employees don't know where to go. So you might be able to dodge that. But if he goes to the NLRB, it's a pretty clear loser under what the circumstances are in this case.
Hey, Jerry, what if he posted, "Don't eat the pizzas here, they'll kill you, they're poisonous, rat droppings"?
Well, the board has said if an employee is making comments that are so negative against the employer as to undermine the employer's products to the public, that is not protected concerted activity. So it does make a difference what the comments are.
All right.
Thanks, Jerry.
Thank you, Jerry. All right, so no nonsense?
Another loser.
Yeah. You don't want the NLRB all over you.
No, I do not.
No. Okay, so,
Hold on, we got a question.
yes.
Be for a rule violation.
So that would be post-injury misconduct, according to the rules. Jerry, what do you think on that?
How's your evidence of other employees using
Right.
the telephone during working hours and suffering no disciplinary consequences to the check?
Have you ever posted something on
The
Facebook?
point is, if you have a rule and you enforce the rule, then it's a good rule. If you have a rule and you don't enforce the rule, there is no rule.
Okay. Anything else before we move on to this opioid issue? All right, so no nonsense. I wanted to bring something up to you, which I find fascinating. And as I've tried to sell many times, our firm offers a variety of legal, we cover a lot of areas of practice. With this opioid problem that we're facing with Mr. Black, and I mentioned, the opioid crisis that everyone's aware of. We've got a subrogation unit in our firm that is exploring the potential recovery from opioid manufacturers to try and recoup some of the costs that insurers have incurred due to opioid abuse. Not yet. So anyway, later on, I'd like to maybe get some insight from our gurus in that field, which would be Rich Gerber and Matt Leffler. Would you be interested in hearing about that potential?
Yes, I would be very interested in hearing that potential. I have a lot of bad cases. We've got a lot of people that are hooked on drugs. If there's any way on opiates, and if there's any way I can recoup any of the money that my client that we've been paying out, that my clients are paying out, I would love it.
Perfect. Okay, so basically where we're at now, no nonsense, is I think we need to get rid of this dog in the case. I think I should contact Money Miles and see if we can get this one resolved. We know Money Miles is going after the third-party case. She needs to get us resolved before she can settle that one, and we know she's all about the money. So we've got the issue of future medical because he's still getting pain pills from pain management. We've got permanent partial disability. We've got the issue of rate, which could go either way with regard to his future earning capacity. We've got our safety penalty that we've been taking, although we don't know that it's the strongest. And then we've got this ongoing use of medication. So if I was going to assess your exposure, for the concussion, I'm thinking 10 to 15% of the body, but then you have future medical, and then you have all these unauthorized ER bills that he could come back and successfully claim that we owe. So what do you want to give me for authority?
I'll give you 20 grand, all issues, future
Okay.
medical, any disputed TTD, PPD, disfigurement, if he's from hitting his head or whatever, and see what you can do with that. And if you can get it closed for that, then.
All right. And no nonsense, since we have a subrogation interest and lien on the third-party case, how would you like to handle that?
I would like
you got
you
another
to,
call coming in?
Apparently I do. Ring, ring, ring. Rudiger. I mean, Rudiger.
Yeah, but do you want me to handle it, or are you going to?
You handle it. No, you
want me to handle it?
Yeah, you handle
Okay,
it. You handle it, and if you're successful, girl, I'll nominate you for the Nobel Pizza Prize.
Is that Nobel Pizza Prize?
Pizza Prize. Pizza Prize. You got too much competition for the Pizza Prize, girl.
Okay. Do you ever want me to contact you again in this scenario?
Sure.
No, you're supposed to say no.
No. I do not want to hear from you.
Yeah, I know you don't.
Just get it done. I want the steps on. I'm hoping that you can get this done, get the steps on my desk by the time I come back from my long-awaited vacation.
Yeah, I was going to say, it seems like you want to stop working here and go to New Orleans for Jazz Fest.
I definitely am leaving in about half an hour.
Okay, very good, very good. Okay, I'll call Money Miles and see if we can resolve this thing.
Thank you.
Ring, ring.
Hello.
Money?
Hey, it's me.
It's Elizabeth Schock Legal calling you on your stellar client, Jack Black.
Great. But before we talk about Mr. Black, I'm taking a survey, so let me know what you think. Because I've been working on these marketing things, right?
Oh, yes.
Okay, so tell me how you feel about the first one. Money Miles, the name on your claim. What do you think? Okay, that's number one. Number two, Money Miles, put my face on your case. Which one do you like better?
I don't like either of them. I have a couple of my own.
See? Okay, well, let me see.
You know, my motto for you is no smiles in my Miles files.
All right, that does rhyme.
Yeah.
All right,
Yeah.
I'll get back to you.
The other one I like better is money talks, but only people watching TV at 3 a.m. listen.
You know what? Yeah, I like it. I could work with that if I make it a rap. All right, I'll make a note about that.
All right, getting back to Jack Black, can we get this one settled? I know you have your third-party case going on. My client wants to get rid of this. We've got a lot of issues with your guy. You know, he's taken a lot of pain pills. He's tested positive for marijuana. What do you want to do with this guy?
I mean, first off, you know you can't prove all the allegations you have about his drug use and opioid use. I mean, I think I have a firm argument that work comp is his supplier. So I don't know how you're going to claim that he's really responsible for being hooked on these drugs. But anyway, all that said, you know, I'll clean him up at trial. So let's do around about $25,000, whatever that comes out to.
Okay, you know we have a subrogation lien,
Right.
and I know you're going to ask me to waive that lien.
Yes.
And you know
Waive it, please.
And you know I'm going to tell you that we never waive our subrogation lien.
Wah, wah, wah.
Okay, so you're $25,000. All right, money. You know I'm straight with you.
Yes,
I don't mess around.
that is true.
So I'm going to give you everything I got. $10,000. Full and final, future medical, rate issue, 10 grand.
All right, Beth. And you know, Shock Legal, I always keep it real with you too, right?
Right.
And you may not know that my client's real name is not Jack. Did you know that?
No, I haven't had the pleasure outside his deposition to get to know him, although he testified that it was Jack, so maybe he perjured himself.
Well, you know, he's on these meds that your client gives him and he forgets things. But his real name is Jesus. So, I don't know what you think is gonna happen when I walk into the division with Jesus, okay? So, I asked you for 25, give me 20, we're done.
You know, let's cut to the chase. I can recommend $15,500 and you protect our lien.
15.5, protect the lien. What's that, like 17 and a half, 20 bodies a whole, something like that?
Yeah, I think it's somewhere around there.
All right, I'll take it to him.
Okay, very good.
Thanks. I'll give you a call back after I work out the third-party case.
Perfect.
All righty. Ring, ring.
Stingy Sean.
Stingy, how are you?
Terrible now you called me, but what's up?
I'm so sorry. I'm so sorry. You should be excited every time I call.
Never excited.
That means we're going to wrap something up.
We'll see.
All right, fine. Look, I'm giving you a call on Jesus, AKA Jack Black. All right? You got my demand. I gave you time to look it over. I complied with the new statute, et cetera, but I don't have a check. What's going on?
So I've looked at it. It's insane even for you. The best I can do at this point, it's unreasonable, it's inflated, as always. I'm rejecting it, as I told you 89 days ago. 30,000 is the best I can do.
I'm sorry, what?
30.
30,000.
30,000.
You know Money Miles
That won't cover a
takes-
billboard, but 30.
No. Money Miles takes serious cases for serious money. I can't do this for 30. That's not working out.
Okay.
You know my guy has a concussion, multiple ER visits, problems at work. They're now claiming he's a drug dealer. That's defamatory, so I'll have to file that case. They're trying to fire him, so I have to file that case and deal with Jerry at E&D. I don't have time for all of this. So you're gonna have to do way better than 30 grand.
Money, I got records from the hospital, and I got records from Dr. Brown Chiropractic. There's 25,000 billed. There's like 10,000 paid after adjustments and write-offs, and you got a pothead, as this no-nonsense says it.
So you say?
And, you know, I'm being pretty generous. You know, there's some liability issues, so I think you're taking a big risk, and we both know you won't try this case.
Oh, you think I won't? Look, I get all my defenses from Lifetime,
trials,
okay?
Miles.
The coach did it, the nanny did it, his girlfriend did it, your client
you
did
didn't get your
it.
bus stop ads by trying cases. I know that, so.
Touche, but every so often I go.
But in light of the new collateral source rule, I think you're really up a creek.
No, you can't even prove the collateral source rule is going to apply here, but I'll let you give me the spiel. Go
Well,
ahead.
I will give you the spiel, and I get to tell all you guys a spiel on some new lovely case law in Missouri, and I will keep it brief. But another chance for kind of step away from the play, I guess, to talk about the new rule in Missouri. Back in August, it was signed into law and passed by by the state government, signed into law by Governor Greitens. August 28th, 2017, it went into effect. So it effectively changed the collateral source rule. So back in, previously, the collateral source rule was used to prevent, defendants from showing that the plaintiff received payments from other sources in order to reduce damages. You didn't really, in essence, you didn't want to award a plaintiff for maintaining health insurance, right? And like everything, as we talked about with the 537.065 stuff, there's unintended consequences. So what happened was, you started seeing these insertion and trial of bills that were quote unquote sticker price. So it's what was all charged by the medical provider, but was never paid by the plaintiff. So they were essentially double dipping. You'd have 30 grand in med, right? But then you'd have write-offs and adjustments, and at the end of the day, $8,000 was only paid. So you had these people claiming losses of the 30,000, being awarded judgments based on that number, but never actually owing it. So the new collateral source rule went into effect on August 28th. And what that does is that changes what can be, it's supposed to change, what can be demonstrated at trial. So what you see, the major change of the statute is that under the new statute, a party may introduce evidence of the actual cost of the treatment. And they have defined the term actual cost to mean a sum of money not to exceed the dollar amounts paid by or on behalf of a plaintiff, plus any remaining dollar amount necessary to satisfy the financial obligation for the care. So essentially what you're going to get now, what you're supposed to get now, is at trial, you will only get the number that has been paid by the plaintiff or its insurer, not this pie-in-the-sky number that no one will ever pay, right? And that should be defense-friendly. But again, like everything, there are either unintended consequences or, the plaintiffs have already shot holes in it. So so far, as I said, it's August 28th, 2017. It's barely been 7-8 months. You don't see, there's no appellate decisions on it, but as of right now, a couple courts have decided, the Western District of Missouri Federal Court and Eastern District of Missouri Federal Court have both decided, as well as St. Louis County, that this does not apply retroactively. So if your claim's filed prior to August 28, 2017, you're stuck with the old collateral source rule where anything goes. The other issue is that what you're seeing now, and I've seen this in 3 cases already, is plaintiffs aren't submitting bills to their client's insurance company, so they're not paid. So it will comply with the statute because it will be owed by the plaintiff at some point. And so then they can take that pie-in-the-sky number that hasn't been written off or adjusted, and they can put that in a trial. We haven't seen how that's gone yet, but I do have 2 cases where I settled one maybe 2 months ago where there was $21,000 in med. He didn't submit barely a dime to his insurance company. And you're kind of stuck. You don't know. There's no guidance, right? Because again, like the 537.065, you don't know what's going to happen. And it's, you'll know better in a year. But at this point, it's something to consider. You may see it more with the bills, but at least for right now, I can use it to negotiate with money over here, but she's a tough cookie, so.
That's right. Can I just jump in here real quickly to address the collateral source under work comp? Unfortunately, this doesn't affect us, and we in the work comp arena still have the statutory provision that we can't introduce any evidence of a collateral source. So the way the case law has come down is we as employers and insurers are very, pretty much completely limited in trying to argue that, look, his insurance paid this. We'll pay back what his insurance paid, but we're not paying the full price of the bill because he doesn't owe it. And the courts have said you can't introduce that evidence that's been paid. So then you have employees, attorneys introducing full bills, and you have judges awarding the full bills, and you have them awarding it directly to the claimant. So it's a complete windfall. And until our statute gets in line with this or gets rid of that collateral source provision, we're still stuck in a very hard position.
Back to it.
All right. Well, Sean, I heard what you said, and
You were so lucky to hear all that.
I
So
did.
convenient, so back to it.
Exactly. I mean, and honestly, at trial, I don't have to offer the bills at all. Juries are smart. I could tell them this guy had a concussion. He's been to the ER multiple times. They can guesstimate as to how much that is. Or I really can just offer all the bills, what we deem to be their true value, which is what is charged, and then you're stuck with the hurdle of trying to say that I'm not right.
We're still going to have to get a doctor in there to relate it all back to the accident, and I don't know if you want to pay for that.
Wait a minute, accident. Okay, I just had a thought. You know, have I given you my marketing survey yet?
No,
Okay.
but please.
But I'm thinking, okay, how about this commercial? Like, I'm in the jury, standing in the jury box, you know, and the American flag's waving behind me and stuff. And then I'm like, St. Louis, when they violated your right of way, call me right away. What do you think? You like that one?
And then Jesus himself comes
Yes, yes. That's awesome. I'm doing that one. Okay. So look, what are we talking about? Let's just cut to the bricks.
I can tell you that I'm going to make you an offer, and most of it's coming from me not wanting to deal with you anymore.
You know what, Sean? That hurts me. That hurts me down deep.
So
But as long as it doesn't hurt my
how's
purse,
it?
I don't
40
care.
for the injury and 25 for just for you to go away, so 65 total.
Will you always have go away money for me?
Always.
All right. All right, so 65.
65 is the number.
We split the baby. All right, let me talk to Mr. Black and I'll get back to you.
All right.
Great, thanks. Ring, ring.
Elizabeth Shack Legal.
Shock Legal. Money Miles on Jack Black.
Hey, Money, what's up?
Look, I just
Got
said,
good news for me?
I do. I just settled the third-party case with go away money. Did you know that was a thing?
When you're involved, yes, it's always a thing.
Hey, whatever feels.
I'm gonna give you $5 to hang up right now.
Just $5. I got 20 grand from Stingy Sean. You gotta step it up. All right, so look, we settled the third-party case for $65,000.
Okay.
How much do you have in on the comp case?
Okay, so our lien money totals $90,000. We've paid $2,500 in temporary benefits, indemnity. We paid $70,000 in medical, and we're giving you $15,500 for permanency. So our total lien amount is $90,000.
$90,000. All right, so you know, obviously, that's way more than what I settled the third-party case for. So how about we just work it out with a third, and we don't have to go through all that Rudiger math.
All right, well, how about we first go through the Rudiger math? Okay, so the Rudiger formula provides the formula for determining what a workers' compensation carrier is entitled to from the third-party recovery. And it's pretty, I've laid it out pretty simply, but you take the total paid work comp, which I just told you was $90,000, right? The $2,500 in indemnity, $70,000 in medical, $15,500 in permanency, totals the $90,000. You take that gross third-party settlement that she talked about, the $65,000 that she's getting. You subtract her fees and costs of $25,000 in this case. And so the net that Mr. Black's going to get out of that third party is $40,000. We don't have a right to go after Money's money because she has to work and get paid for what she does. So we have a right to the 40 or a portion of it based on this figure. We then take our $90,000 total that we paid. We take it over the gross settlement of $65,000, and then we take that times the net recovery, and then that'll give us the dollar amount. In this case, it's going to give us the full recovery because it's more than, so it's going to be 100% recovery. So in theory, we're entitled to the full $40,000. Where does that leave Mr. Black? Well, it leaves him with nothing from the third party, and it leaves Money with her $25,000. But in this case, Money's just not in it for the money. So
That's right.
she wants her client to get something. So what's your proposal?
Right, because you know we can't have this situation where I'm getting all the money. As much as I would love to, that's not ethically correct
Well,
for
you
my
could
client.
just give it to him.
I'm sorry, what?
What would Jesus do?
Touche, Beth. Touche, Beth. Yes. But I mean, honestly, we have to talk about this lien situation because I feel like all these carriers and all these defense counsel basically want me to do all their work for them, and then my client and I don't get paid for it.
I get that.
You know, it's like you send me to Ted Drew's for concrete, and then I bring it back to you and watch you eat it. Like,
Yeah.
what's in it for me?
Yeah, I won't hold my breath on that.
I would consider bringing you some Ted Drew's, and then you can give me some go-away money. But look, really, let's go back to my third proposal, or something very close to that. So that
Okay.
way, Jesus gets paid, I get paid, and you get some of your recovery.
All right. So going back to, you know, this interaction, when it makes sense, in this case, it might make sense to compromise on the third-party recovery because we have a bad plaintiff. I mean, he's hooked on drugs, he's a pothead. We can pursue it as the employer, but we're not going to have a very good time doing so without Mr. Black's, I refuse to call him Jesus, without his participation and without him being credible. Like she pointed out, is she really going to do this for just her to get paid? Probably yes, but in this scenario, no. And then, you know, another tactic that plaintiffs' attorneys use is to raise comparative fault and try to reduce our lien by saying that, you know, there's some comparative fault and maybe that's not the right amount. So in situations, this is a big discrepancy, but just bear with me. In some situations, it does make sense to compromise, and I think a lot of people in this room have done that on cases. Because for us to go after it without the help of Money Miles in this situation is going to be difficult. So-
Right, and on our math, we know the numbers are kind of farther apart, but I'm sure, as Beth said, we've compromised this in many situations, and a lot of time it just breaks down to, do you want your guaranteed money within 2 weeks, or do you want to wait for maybe money in 2 years?
Yeah.
After a trial and appeal and all the other fees and expenses, et cetera.
Right, and if she's not going after it, that means we're going after it, which means you're paying a lawyer to try to go after it. And so in some situations, when you're dealing with your subrogation recovery, it does make sense to cut those deals and get a guaranteed amount versus waiting for an unknown amount.
Exactly.
All right, so we're willing to work with you on it.
All right, we'll discuss. Thank you so much. And let me know if you think of any other good slogans for me, because I want to get my new campaign on the air in the 2 o'clock slot during Judge
2
Judy
a.m.?
and such.
2 a.m.?
No, during Judge Mathis.
moving
and
it up
Judge
an
Judy
hour?
and all that, yeah.
Yeah.
All right.
Okay, Steve?
Well, that wraps up the scenario. Give a round of applause for our actors. Turns out I ran into Jack Black a couple months ago, and he bought a fleet of small cars and upped his drug dealing game, and he's serving time in county now. So all's well that ends well, right?
So it's more of an employment law bent. Might be good for some of the employers that are here or folks that deal with the employers. And Jerry's always available too for phone calls and questions. And we're also going to put this information on the website along with the case law update, so it should be readily available. All right. I'm going to hand it back to Beth, and then she will do the introductions on the next. And then don't leave right away because we got to do the raffle drawings.
This is my final appearance. Please hold your applause for later. Standing ovations are not necessary. Anyway, I alluded earlier in the program about our subrogation attorneys who are pursuing this potential recovery for the opioid manufacturers. So while listening to this part of the program, think about those cases that we've all had that have gone south because the claimant gets hooked on opioids. I've had them. They never end well. So it's a fascinating topic to me. We're going to hear from Rich Gerber and Matt Leffler. They do not have nicknames. So your job while listening to them is to text in good nicknames for both of them to Steve, and we'll reveal the winner. Okay, Rich and Matt?
All right, testing, can you hear me? Is this working? All right, I'll speak loud.
Is green?
No, is yours
You're,
working?
you're purple.
I'm purple. It is
It's off.
It's on. It's on. All right, my name is Rich Gerber. I am a subrogation attorney at Evans and Dixon. I'm going to just briefly introduce really my partner Matt, but tell you a little bit about our practice and how we got involved in the opioid subrogation. So we have a national property subrogation practice all across the country. We also do quite a bit of workers' compensation subrogation. We have a team of lawyers. That is all we do. We're not work comp lawyers. We're not defense lawyers. We are plaintiffs' lawyers who handle only subrogation, and that's it. So my practice takes me all over the country, from California to Maine. Whenever there's large losses, we're there at the scene inspections, building the case from the inception. And over the last 6 months to the maybe 2 years, I have heard more and more subrogation attorneys talking about the lawsuits for the opioid crisis that the states, municipalities, and governments have been bringing across the country. And over the last 6 months, there have been settlements, very large settlements. The gist of the lawsuits is a county incurs medical costs, law enforcement costs, imprisonment, food stamps, all related to people who are addicted to opioids. And we started to think as subrogation lawyers, well, wait a second, who's really paying for those? If it's not governmental funds, it's your money, it's the insurance companies. So about 6 months, 8 months ago, we started to look closer and closer to this, and now we're getting to the point where we are ready to start filing subrogation lawsuits on behalf of the work comp carriers and the employers seeking reimbursement of the cost of opioid addiction, the excessive prescribing, and all the costs related, the lost work, all related to the opioid issues. So this is my partner, Matt Leffler. I tasked Matt with looking into this months ago. We're very close to starting to file our first lawsuits, getting involved in the MDL, multi-district litigation, and Matt has been working on it, and he's going to talk a little bit more about it.
Yeah, and just keep this in mind as I go. Our subrogation action is going to be against the manufacturers of the pills. So, and the distributors. It's not a cause of action against the doctors. Just in case there are any doctors in the room, I wanted to point that out. 3 goals today, just to go quick. 1, we're going to go quick because I know everybody's hungry. Good news on that is if any of you are Mike Banahan clients, he's agreed, always a free spender, to take his clients to Burger King on him after this. So we'll go quick because it's lunchtime. 2, we want to give you guys a feel just for the opioid epidemic. What is it? What does it mean? And then number 3, what does it mean to work comp carriers and how has it affected them? And then what can we do on the subrogation side to try to get that money back? And then maybe some of you will be able to go into your office tomorrow morning and come up with the original idea of subrogating on opioids and get a promotion and a big raise that are very prevalent in the insurance industry. So real quick, just some statistics. Opioid prescriptions are up 400% since 1999. Some of these, and I'll read them real quick, but they just shocked me. 42,249 people died from overdosing on opioids 2016. 11.5 million misused prescription opioids in 2016. 2.1 million people misused prescription opioids for the first time in 2016. And $504 billion in economic cost in 2016. If you've read some of the recent newspaper articles, this isn't really slowing down. The CDC came out with some guidelines in 2016, but even new statistics, and I think it was in the paper today, in Missouri, the prescription writing on opioids is actually going up some parts and not going down. How does it affect you guys? How does it affect the comp carriers? Workers' compensation industry spends $3 billion a year on pain medication. To me, that's a staggering figure. Rich kind of felt the same way. Of the $3 billion, $2 billion a year is spent specifically on opioid prescriptions. That's your pain pills. Prior to 2016, when the CDC issued guidelines, recommended doctors avoid issuing opioid prescriptions for longer than 3 days. 99% of the doctors were prescribing opioids for longer than 3 days. And so one of the things that we're looking at, and one of the questions we constantly get in the subrogation side of this is, well, how do I know what to look up? You know, what are my quote damages? And one of the things that we're doing is telling people to go through their systems and do internal audits and flag stuff, okay? And on the onset, we're gonna have our clients flag stuff, and then eventually we're gonna go back and look in detail. But one of the things that they're flagging is anything other than a major surgery where opioids are being prescribed for more than 3 days, and then a major surgery if opioids are prescribed for more than 7 days. We're flagging those. Now that doesn't mean that eventually those are gonna be incorporated into the subro action, but that just means those are the things that we're gonna have our doctors and our experts look at down the line. We can go to the next. You know, going back to what are some of the damages that we're gonna be seeking in the action, and keep in mind, health insurers and third-party payers are already entering into the MDL that we'll talk about in a second. So this is something new, but it's also something that other industries and other insurers have already started taking advantage of. You know, opioid prescription for the workers, that's an obvious one, right? If someone's hooked on opioids and the comp carrier is paying that for, you know, sometimes you guys have seen it for over 2 years. That's a damage that we're gonna look at. The addiction treatment, the additional TTD, the additional time off work to deal with the addiction, you know, medical care related to the addiction, and then death benefits if the addiction leads to death, all covered by workers' compensation. Yep. If you can chime in here too. There's a multi-district litigation, and it's already filed in the Northern District of Ohio.
So the multi-district litigation, is that too loud now? I'll go down a little bit. A lot of work comp carriers are going to be getting involved in this. Multi-district litigation means that instead of having 250 lawsuits in different districts and federal courts, all of them are going to be combined into one lawsuit, basically, where the discovery is done for all the cases. So it's a way to share expenses, it's a way to be cost efficient for the courts, but it's really for the benefit of the insurance companies and the self-insured employers, where it's not going to cost you as much as you would think to go through, you know, very time-consuming litigation. The key here is that you need to find a way to get into your systems and flag the potential employees, injured employees who could have lawsuits. And we can help you with that. We're going to help you with that. Go ahead.
We're looking 10 years back right now. And everything's new and everything's the beginning, but from a frame of reference time-wise, we're looking 10 years back from present.
Right. So if what you need to do is go back and speak with the people who have, you know, the decision-making, and give us a call. This is all you're going to be. They're probably already getting phone calls from lawyers across the country, people who do multi-district litigation, who do class action. You know, we have relationships with all of you. This is what we do as subrogation. We are going to be involved in this multi-district litigation. We are hoping to get a seat on the steering committees so we could have some say-so in the discovery process. You know, the goal here is not to just tag along, but to be involved and try to get your companies a larger recovery. But the key is that this needs to be done soon, in the next month, 2 months, where we have to go back and look into your systems and key it properly to find out which claims are actionable.
Yeah, just to speak to the urgency of the 2 months, in the multi-district litigation in federal court in Cleveland, the judge has already issued his scheduling order, okay? And in the scheduling order already has certain deadlines. So if you're going to come in and try to enter into the case after the deadline's passed, you risk just being completely left out, because this is going to be potentially the sole remedy.
If you're not sure, we don't have time to go through all this. We only have 10 minutes. We've already used up our allotment. But give us a call. You know where to find us. We will talk to you. We'll learn a little bit more about your systems. If we need to, we could we could give you some suggestions on how to do the searches and how to find these claims. So, questions?
Mike's right back there, by the way.
As an aside, the first one is already settled, I think, for $24 million in Kentucky. Somebody had a question in back? Nope. All right. Thank
All
you.
right. Thank you very much. Somebody did text in, and so keeping in line with our earlier production, we'd like to thank Recovery Rich and My Money Matt for their help today.
Mo Money Matt. Okay.
Thanks, guys. Well, that's it. Thanks for coming out. We would like to at least take a moment. As many of you might know, one of our colleagues has been battling some health issues, Michelle Wolf. So if you could, please keep her and her family in your thoughts. We wanted to put up the GoFundMe page. If you need it, we can text it to you. We can send it to you by email. It's Michelle Eric Wolf hyphen 1172064. And again, if you need that, just contact anybody, the texter or something. Somebody will get back to you. Now.